Act of the Nationality, Immigration and Asylum Act 2002 in the UK. The Nationality, Immigration and Asylum Act 2002 represents a major legislative development in the United Kingdom, immigration and nationality law. The act was enacted to reform asylum procedures, strengthen immigration control, and address challenges associated with the management of migration in the early 21st century. It expressly reflects the government's response to growing concerns over asylum claims, irregular migration, and the need to streamline administrative processes. This video, I shall talk you through the impact of the Nationality, Immigration and Asylum Act 2002 and explore its historical background, key provisions, administrative and legal consequences, and I will evaluate its effectiveness and criticisms. The video argues that while the acts introduced significant procedural and administrative reforms, it also raised concerns about fairness, human rights, and access to justice. Historical context. Asylum and immigration prior to 2002 in the United Kingdom. Before 2002, the UK faced a growing number of asylum claims, especially during the 1990s. Existing legislation, including the Immigration Act 1971 and subsequent amendments, proved insufficient to manage the increasing volume of claims and the complexity of international migration. Policy pressures. The government sought to balance humanitarian obligations with concerns about border control, fraud prevention, and the efficiency of the asylum system. These pressures culminated in the enactment of the 2002 Act. Structure of the Act. Key provisions. The Act is divided into several parts addressing the following. 1. Immigration control and entry. Asylum procedures. Nationality matters. Enforcement and compliance. Two, legal terminology associated with the 2002 Act. Important terms introduced or clarified by the Act include the following: dispersal of asylum seekers, fast-track procedures, support for asylum applicants, deprivation of nationality under specific circumstances, reform of asylum procedures, streamlining applications. The Act introduced reforms to make asylum procedures more efficient, including the following: fast-track processing for certain claims, clearer criteria for admissibility, improved administrative processes, support for asylum seekers. Provisions were introduced to regulate support, including housing, financial assistance, and access to services, while ensuring compliance with immigration control objectives. Dispersal policy. The dispersal of asylum seekers across different regions was formalized, reducing pressure on particular local authorities and improving management of accommodation. Immigration control measures. Enforcement of powers. The Act streamlined the powers of immigration officers to arrest and detain individuals, remove those without legal status, investigate fraudulent claims, detention and appeals. Provisions clarify the use of detention and streamlined the appeals process to expedite cases. Nationality provisions. Deprivation of citizenship. The Act provided the Secretary of State with powers to deprive individuals of citizenship under specific circumstances, such as fraud or national security concerns. Registration and naturalization. The Act also clarified procedures for registration and naturalization, ensuring consistency with broader immigration policy. Administrative and legal impact. Streamlined processes. The Act facilitated quicker decision making, reducing backlogs in asylum and immigration applications. Judicial oversight. Courts maintained oversight through judicial review and appeals, thereby ensuring compliance with human rights obligations, and legal standards. Balancing control and protection. The Act sought to balance effective border control with the UK's obligations under international law, particularly the 1951 Refugee Convention. Criticisms of the Act. Access to justice. Some critics argue that fast-track procedures and stricter controls limited asylum seekers' ability to access legal representation and fully present their cases. Human rights concerns. The Act raised concerns regarding detention, removal, and deprivation of citizenship, particularly in cases involving vulnerable individuals. Administrative complexity. Despite streamlining efforts, the Act introduced complex administrative structures that could be difficult for applicants and officials to navigate. Subsequent reforms. Immigration and Asylum Act 2004. The 2002 Act laid the foundation for further reforms, including the Immigration Asylum Act 2004, which continued to refine asylum procedures and enforcement mechanisms. Modern relevance. The 2002 Act remains relevant as a legal foundation for immigration and nationality matters, particularly concerning asylum administration and enforcement. Evaluation. Strengths. Improve administrative efficiency. Clearer procedures for asylum claims. Enhance enforcement powers. Weaknesses. Potential limitations on fairness and access to justice. Human rights concerns regarding detention and deprivation of citizenship. Complexity in immigration. Future considerations. Ongoing review and reform are needed to ensure that immigration and asylum law balances efficiency, fairness, and human rights protection. In conclusion, the Nationality, Immigration and Asylum Act 2002 represent a significant step in the evolution of UK immigration law. It introduced key reforms in asylum procedures, strengthened immigration control, and clarified nationality matters. While it achieved important administrative and procedural improvements, it also raised questions about fairness, human rights, and the balance of executive power. Understanding the Act is essential for policymakers, practitioners, and scholars seeking to navigate the complexities of UK immigration and asylum law. Please comment, like, and share this video. Thank you.